Hey, so in class, I started talking about the next assignment, and unfortunately, the recording didn't work very well. It all got a little bit muddled. So I'm just going to make another little quick recording now for you, make sure we're all on the same page. So, firstly, I hope you're excited about this assignment. I'm actually kind of looking forward to marking them. I don't usually look forward to marking, but I am looking forward to marking these. I've got to say, it is a tricky assignment. There's a lot in it. So you really do need to be thoughtful and proactive and really think about the approach that you want to take. So read the problem carefully. I've got it on the screen in front of us. And really make sure that you spend time mapping out what the facts are and making sure that you have a good read of both what the client has asked for and understand what it is that you need to do. So in particular, let me do it here. Um, Dennis has set out for you what your instructions are here. So it's really important that you make sure you understand your instructions. So the advice I gave the class was to go back to the recording that I made earlier in the year about how to write a memorandum of advice. And particularly think about the audience for the memorandum and think about the audience for your letter. Now, these think about the objective of what this assignment is doing. What you need to do is solve a relatively complex legal problem, and you need to talk to another lawyer about your findings. You also need to convince that other lawyer that they're not going to be doing the wrong thing if they sign the draft letter that you prepared for the client. Now, the client that you're writing to is not a lawyer, not an Australian lawyer anyway, and you've been specifically told to assume that they don't know anything about the Australian law. So you need to think about your audience, and this is your opportunity to translate your complex legal advice delivered using appropriate legal terminology into plain English for somebody who doesn't understand why it's necessary to dig into the various formation elements. So you need to deliver the whole piece as 3,000 words. I would see that basically as a benchmark. How you mix it up between the two is up to you, but let me tell you, I've never had a client tell me, please send me a long letter. Clients want short, straight to the point letters, and your boss needs to know what is inside that document, what's inside the letter, and that it makes sense. Try and avoid repeating yourself. You don't repeat in the letter what you've said in the memo. The memo basically is presenting a draft to Dennis to sign, and you might explain why in paragraph 2 you've dealt with X, Y, or Z. Or you might explain that you looked at issue ABC, and for these reasons you don't believe it's relevant, so you haven't put it into the letter. Part of this process is about juggling all of these things you need to do, demonstrating that you understand what the problem is. You can make judicious choices about what to include in the letter and what to exclude. That you can make choices about where to spend most of your energy or your words on the important issues. So you're asked to do a couple of things. Dennis has quite helpfully, I think, pointed out this relatively recent case to you, and you might need to have a look at that and think about it's relevant to the problem at hand. You've also got this draft document. Well, it says it's a draft document, but it's interesting, isn't it? It's actually been signed by the parties. And your client earlier has said, just let's go back up to the email from Harvey. So the person that you're speaking to has basically says, seems to me we've got a deal already. So you're going to have to work out, well, how do we deal with this document that says it's a draft, yet the parties seem to think is a deal? what does that matter? Does it matter? Is the whole thing binding? Are parts of it binding? What's relevant? And Dennis seems to think this case would help you, and so I think you should take Dennis's advice and at least be able to explain to him how it's helpful or not helpful. The other thing that he suggests that you do is have a look at, let me make sure I've got my pointer here, the Encyclopedia of Forms and Precedents. So I'm going to flick into that. Sorry, it should come up here. And you can see why he thinks this might be helpful to you. So that link should take you, I don't know how Dennis has got a link to the RMIT library, but it should take you there. You're going to need to log in. I've got a password database, so hopefully this will happen pretty quickly. So basically, the Encyclopedia of Forms and Precedents is a tool that lawyers use quite a lot. Sorry, there's a dual process here. So once again, you have to actually log in the second time. So this database is something that law firms will use a lot. They will also have their own precedent database or precedent collection, and that, depending on the firm, might just be a collection of useful documents that they've used before where they're just changing the names, right through to systems that use artificial intelligence and document learning or machine learning technologies in order to build documents. Now, I'm going to give you a bit of a heads up here. Heads of agreement is a good place to start. You might also search for preliminary agreement, letter of intent, really looking at what kind of precedent is that Dennis might be using and whether there are problems with his existing document or not. Now that search brings up quite a few different things, but as I come down here, I see we've got something that's called a heads of agreement for the sale of shares. Now that sounds pretty useful to me. So I'm going to flick straight into that and have a look at what that content is. Now, what's interesting here is this will take you through the materials. So you can actually browse the table of contents if you want to, and you'll see here, sorry about that. Just go back again. I often find that personally quite useful because I'm somebody who works well when I understand the context of how things fit together, probably better than just searching by random search tools. So basically, as you can see here, we've got, it's part of Precedents Sale of Business. It's sitting in the pre-transactional space where there are two references to whatever it was we were looking for. I'll just flick into here. So starting with sale of assets, there are some introductory notes. All of that is likely to be helpful and useful reading. So back to the heads of agreement for a sale of shares, which is what we're talking about here. This link here will let you actually download a Word document. And that would be something that is really quite useful to you if you were in a law firm and you were having to create a document from scratch. It might be something that you want to look at here as well. The rest of the text, and this is reproduced in the document, sits in the web page here. So you can have a look at the kind of terms that are in this precedent that's being created here by part of a series of commercial transactions prepared by Murray Landis, who is a partner at K&L Gates. So the other thing that's useful about these documents is that they also provide commentary information. So you can read the commentary and see why the clauses have been included or excluded. So just actually going back into our search results before, that heads of agreement that we were having a look at didn't seem to come with commentary. So one of the things that we notice here that actually the commentary is quite small. This gives us an idea about what the provisions might include and gives you an opportunity to compare the standard form with something that Dennis has prepared, but it's not really explaining at this point why the provisions are in there. So if we go back to our original search term, you might end up searching again, looking for commentary, but I did notice here, yeah, commentary to letters of comfort and letters of intent. So this could be useful to us as well. Let's have a quick flick in. And we can see here there's a lot more commentary. This title deals with two related but separate topics. Oh, sorry, it's jumped very quickly. Letters of comfort and letters of intent. And so here, basically, we've got commentary or provisions, including you'll see references to Masters and Cameron here. Talking about the reasons that things are included in this particular precedent, the precedent for the letter of intent. Another place to look is in the boilerplate clauses. So boilerplate is a term, to be quite frank, I'm not sure where it came from, that lawyers use to talk about the kind of scaffolding agreements. So the clauses that have been developed over time, I mean, they're not terms of art, but you will see similar clauses in many agreements that often deal with the kinds of things that we've been addressing in the classes that we've done so far. So these are the clauses that provide the agreement between the parties in relation to specific matters that if there wasn't a specific agreement, the courts would deal with them in a particular way. So let me give a more concrete example. Notices clauses. Notices clauses will stipulate the parties' agreements as to what time and place a notice will have effect. So you'll remember the postal acceptance rule and Lidsell and Adams and Lidsell, which essentially says that if you put a letter in the post saying that you're accepting an offer, then the acceptance happens at the time and the place that the letter is posted. Now, often that won't suit either party, so instead the offer will stipulate a term that says that the post can be used as a form for accepting the offer, but acceptance will be deemed to occur when and where it's received. And subsequent notices in agreement. So if an agreement includes a notices clause, it often does. So if I think you'll breach this agreement, then I need to give you a notice before I wander off to court. Or if I'm happy with the cubby houses when they're delivered, I'll give you a notice and I have to pay you 7 days after the notice is received. Or you have to pay me 7 days after I give you a notice or an invoice. Those kind of things. The notices clause will deal with the time and the place that acceptance occurs. So let's have a look at what that looks like in real life. So I find the easiest way to find the boilerplate clauses is to just pop down into the table of content. But you can also, of course, search for the particular kind of clause that you're looking for. You'll see that there's a commentary section and then there's a range of different clauses. So the one that I was just talking about is the notices clause. And if we pop in and have a look at that, oh, I think I had it already open actually. We'll see you can download the document. Sorry about that. It was already open, ready and waiting for you. And we've got a clause here. Each of them has little footnotes. The footnotes basically provide some more guidance and you can cross-link in back to the commentary, which I assume is the overall commentary, and you can wander down there and have a look at each of those. I think you'll find that quite edifying and quite useful reading.